Your Worship, I heard something that my colleague says that they would want to interview those witnesses. Meet those witnesses.
And I never said that. I would have stopped him there and there. Is there anything else that you wish to?
Nothing, Your Worship.
You know, at first, this kind of application should be done in the form of a request for further particulars, but it doesn't matter because you already started to bring this application for disclosure of the names and the address of the witnesses. But of more paramount importance is that the safety of the witnesses is very, very important to this court. You know, and whenever one deals with matters of this nature, one has to be very careful in that the lives and of the persons who are to be witnesses are not jeopardized. And under the circumstances, I think that it's adequate for the state to provide them with the content of the docket. In other words, what is it that is contained in the docket? The names and the addresses are protected for good reasons, because there are cases where persons' names and addresses have been revealed, and the next day we see on the news and we hear that those persons have been eliminated by way of death, being killed. And that's the most important thing in this court. Under circumstances, I would then order that the state provide the defense with the outstanding statements of the witnesses that they intend calling in this matter. I think there are how many statements that are outstanding? 3 statements.
Your Worship, from my calculations in relation to the email that I received, it's 4, because we requested some 10 statements, Your Worship.
I hope that those statements are also in the possession of the state. If the state doesn't have them in their possession, then I cannot make an order that they provide something they do not have in their possession. But under the circumstances, you indicate to them, because you should have done it by way of a request for further particulars. Under circumstances, I would order that the state then provide them with the remaining statements of witnesses who might be used in this trial. Okay, if indeed they are outstanding witness statements. Okay, provide the defense so they can prepare for trial. But I would not make an order that the names and the addresses of those witnesses in those statements be revealed at this point in time. The application for have those names and addresses revealed is dismissed. All right. Yes, let's move forward.
Your Worship, I think we'll have to have the matter remanded for my colleague to consult, and then.
And you must provide him as well, state.
Your Worship, I will give them the same statement because I've given them everything. I will just give them the same statements.
But
because what they actually want is the names. That's why they are saying those
the names, we've already dealt with the issue of the names. We are dealing with it. They say there are 4 outstanding statements. But how do you know there are 4 outstanding statements if they are not in the docket?
Exactly.
Can you clarify that?
Your Worship, the reason we were saying 4 is because the email, we have not gone through our request against what is contained in this particular email. Simply because of what I've indicated that we have received this particular email today. So we still need to...
But are you shooting in the dark? Are you shooting in the dark? It seems to me that you are requesting a statement that you have not heard or seen.
Your Worship, we're not shooting in the dark. We can actually ask that this matter stand down, look at the information that they've sent to us against what we have requested in our email, and then we can be in a position to indicate clearly to the court as to what is it that is still outstanding. Because the problem is the state gives us information minutes before the matter is called, so it doesn't give us an opportunity to actually...
What I propose is that I'll give enough time for you. I'm going to adjourn this case, okay? You and the state advocate just compare what documents we have, what documents are outstanding, and see what is it that needs to be disclosed to the defense. Okay?
It's in order.
It's better that way. Okay. Counsel? Right. Okay, give me a date then. I'm going to adjourn this case so that you can then be able to prepare and look through your documents and see what is it that is outstanding.
I don't know whether a week will be enough.
Give them 2 weeks. 2 weeks, 2 weeks is fine, I think. At least that will be enough time for them. Is that the 20th suitable?
Thank you, Worship. Your Worship, we have agreed on the 20th of August, Your Worship.
Okay. And in future, make use of Section 87 when you are requesting further particulars. It does have. If you request for the particulars, it comes Section 87, okay? All right, this case postponed until 20th of August for full disclosure, court number 23. You are in custody. Thank you.